are tweets that I'm looking at, and I appreciate your question. I want to go to Wendy Murphy, and we've got some video of Jordan Davis as a youngster. That's the victim. And there's really wonderful video and photos of a young Jordan Davis. You're going to get to some videos later. There he is with his mom. There he is as a little baby. The jury never saw any of this. Look at that adorable photo of a toddler. And Wendy Murphy, the reason I asked that is Larry Hannon, who's done a lot of good reporting on this, he says, we're beginning to hear second guessing of the job prosecutors did. Complaints that they never let the jury know who Jordan Davis was. One person said the state made a mistake not letting people know who Jordan was. No baby pictures, no stories of his first steps. Did they do everything they possibly could, given the fact that George Zimmerman walked in a case that had, you know, a lot of similarities here?
Yeah, you know, you can get in trouble as a prosecutor if you do too much of the he was a cute baby stuff. It matters to us watching, but prosecutors aren't allowed to be too emotional. I'll say this, Jane. I think this case is an easy prosecution win, but not on premeditation. Here's why. Even though he said to the police, oh, I wasn't that drunk, I had one this and one champagne, his girlfriend said he was basically bombed. Now, I don't know whether he was really, really drunk, but he was clearly drinking enough that he felt he had to lie about it to the cops. The jury knows he lied. They also know he was drinking and he was upset. And guess what happens? Even though it's not a defense under Florida law, voluntary intoxication is not a defense. Mental state because he's upset is not a defense. Juries give out discounts from premeditation, first degree, to second degree if they think to themselves, the guy was drinking and he was scared. He didn't act rationally. That's why I think this case has always been a clear guilty of murder, but not premeditation.
Yeah, but they didn't say that, oh, they're thinking, well, we want to go for a lower count. If they did that, they just would have done that. They said we can't reach a decision on one count, which could be the big count.
On premeditation.
No, not necessarily.
That's where they're stuck.
No,
I know.
No, let's show. Hold on a second. Show all the charges. Put, if you could, thank you. Put up the chart of all the charges, okay? Because you've got first-degree murder of Jordan Davis. There are lesser included. There could be second degree. There could be manslaughter. So, and then the other three are attempted murder. Those involve the teenagers who escaped, drove away. And the first two, first degree is the first one, then second degree is a lesser option, manslaughter is a lesser option. So, Brian Claypool, if they wanted to go for a lesser option, they would have just gone for, they'd just go for a lesser option. They wouldn't say they can't reach a decision.
Yeah, Jane, I think you're right. And I think there's a big problem for the prosecution here. Because think about it. They're looking at the first-degree murder charge first. There are two main facts they have to determine on first-degree murder. One is, was there premeditation? The second one is, was Dunn reasonably justified in using deadly force, i.e. self-defense? I think if they're hung up on the second one, which is self-defense, which I think they could be, because premeditation to me is an easier one to figure out, then that is going to impact the other charges, like second-degree murder and manslaughter, because Dunn can still rely on self-defense on those two